Hey viewers, welcome to the platform of Rational Foundation. Now here in this video we are going to learn the concepts in rational way. In the previous videos of general principles of criminal liability, we have understood the differences between actus reus and mens rea and also the elements of actus reus and also the elements of mens rea and the severity of their offences. Now in this video we are going to learn about statutory offences, mens rea in the statutory offences. Mens rea in statutory offences. Okay. First of all, before understanding statutory offences, what do you mean by statute? Generally, statute means a written law passed by the parliament or the legislature. Okay. This is the statute definition in simple words. In simple words, the statutory offences. First of all, here there are two lines. A statutory offence is an offence created by a statute act passed by the legislature. In India, most criminal offences today are created by the statutes. Okay. In simple words, it is an offence that exists because a statute creates it. Now, in other words, if an act of the parliament says that doing X is an offence, okay, in one of the statute it is mentioned as doing X is an offence. Then this X is called statutory offence. That's it. In a simple way. I hope you understood this. For example, in an act means Negotiable Instruments Act, 8081 makes the dishonor of check, section 138. Section 138, dishonor of check as an offence for insufficiency of funds. And also in Motor Vehicle Act in 1988 creates various offences such as violations relating to driving without required license and also insurance. So these are the offences which are mentioned in the statute. So these will be categorized as the statutory offences. In India, most criminal offences today are created by the statutes. Why did I use this? Is in India, criminal law is codified. So legislature defines what conduct is an offence, and nextly, the essential elements of the offence. Essential elements, and next, it defines the punishment. So statute generally statute of this criminal law is codified, so generally it defines these three things. And next, sometimes we think that statutory offences means only offences under special acts like an act or environmental protection act or motor vehicle act, but this is not correct. Every offence is created by the legislation is a statutory offences. However, when textbook discuss about mens rea and the statutory offences, that means they are usually referring to the special laws only, special statutes like an act and this motor vehicle act and environmental protection act, because these are the areas where the legislature is more likely to create a strict liability, where there are general exceptions for the liability offences and dispense with the proof of mens rea. In the further slides, we will be discussing where mens rea is required and where mens rea is not required. So this is the information with reference to this slide. In the next video, in the next slide, we will be discussing about must the prosecution always prove mens rea or not. Must the prosecution always prove mens rea? Generally, no, because it depends upon the statute. Why? Because criminal law generally punishes blameworthy conduct, not innocent mistakes. Okay. Now here there are two lines. Courts presume that mens rea is required unless the statute expressly or by necessary implication excludes it. This means that if Parliament is silent, courts usually assume that the prosecution must prove guilty mind. Okay. This I will be explaining with an example. Suppose a law says whoever dishonestly removes government property shall be punished. Okay. Now here The word dishonestly itself indicates the mental element. So the prosecution must prove whether A removed the property, and next whatever the act he has done, that removing the property, whether he has the whether he acted dishonestly or not. This also the prosecution must prove. Okay, suppose another statute says any person who sells contaminated food shall be liable whether or not he knew of the contamination. This means that now Parliament has made its intention clear. That is, the prosecution only proves that whether the food was sold and whether this food is contaminated or not. That's it. Here, it did not need to prove that the seller knew about the contamination or not. This is called as strict liability principle, strict liability offense. Okay. Now here, how do courts know about, means in the previous slide I have mentioned about Parliament's intention. Here, how do courts know about Parliament's intention? Because see, first of all we need to understand the concept of mischief rule. In mischief rule, in the interpretation of statutes, mischief rule we have to understand legislative intent. Okay, from this courts infer the Parliament's intention. First of all, what are the factors to derive Parliament's intention? Firstly, the words used in the statute, whether the words dishonestly in the previous example I gave, or knowingly, or intentionally. So, second, the purpose of the statute, whether it is designed to protect public health or public safety or the environment. And next, simple, the nature of the offense. Okay, whether the offense is of serious crime like murder or a regulatory offense such as food safety or pollutory control. That's it. For understanding in a simple way, the presumption in favor of mens rea means when a criminal statute is silent about the mental element, courts ordinarily interpret it as a requiring proof of guilty mind. This presumption can be displaced if the statute expressly or by necessary implication excludes mens rea, particularly in strict liability offences enacted to protect public welfare. These four lines are very complicated. I will explain with simple flowchart. This is the statutory offense. Let us assume. Okay. Does the statute clearly excludes mens rea or not? We have to see whether dishonestly or intentionally or knowingly. These words are exclusively not mentioned in the statute or not. We have to see. Okay. If at all, if it is not mentioned, then courts presume the requirement of mens rea. Okay, and if at all yes, then mens rea is not required. Strict liability. Okay, firstly, is this rule fair or not? Means presumption in favor of mens rea for a criminal statute, whether this rule is fair or not. I will explain this with an example in a rational way. Firstly, imagine you accidentally pick up someone else's suitcase, identical suitcase, in an airport. Okay, genuinely believing that is yours. But if the law punishes you without requiring guilty mind, you could become a criminal because just basing upon the actus reus, and you assume that it is your suitcase and you done that act honestly. So that is why courts generally presume that mens rea is required unless Parliament has clearly denied otherwise. Okay, I hope that you have understood this mens part. Prosecution, mens and also courts presume that mens is required unless the statute expressly or by necessary implication excludes it. Now I think you have understood these two lines and these examples. Now in the further slide, I will be explaining the difference between strict liability and also absolute liability and also case laws related to it. With that, our general principles of criminal liability will be ended. Now in this slide, we are going to cover strict liability and also absolute liability, and after covering these two, we are going to compare strict liability and absolute liability. Firstly, strict liability. Strict liability means the prosecution does not have to prove mens rea, but the accused may still escape liability by proving certain legal defenses if the statute allows them. In simpler terms, see, firstly, actus reus must be proved for strict liability and as well as absolute liability, but mens rea need not be proved. Though there are some exceptions available for this, that mens rea should also be proved. But here in strict liability, general rule is mens rea need not be proved and actus reus must be proved. Okay. Firstly, why was this principle developed? Because to protect the public welfare in all, such as food safety, okay, next public health, and next environmental protection and consumer protection, etc. So, firstly, if the prosecution had to prove what every accused knew or intended, many offenders would escape punishment. Offenders would escape punishment because it is difficult to prove mens rea punishment. Okay. In the previous example, I have quoted that a restaurant sells contaminated food. Okay, contaminated food. And if owner says that I didn't know that the food was contaminated, I said that you have to ask two questions. First, whether the food was served. Yes, the food was sold or served, and whether that food was contaminated or not. Only these two questions for strict liability, because we have to not refer to the intention, knowledge, or negligence part of the owner. So henceforth, mens rea is not necessary for ascertaining strict liability. I hope this is clear. And next, quoting for absolute liability. Absolute liability means, first of all, we think that means I'm asking a general question to you, which is very stricter, means strict liability or absolute liability? Take a pause for 2 seconds and answer this. You may come up with the word strict liability. You think that strict liability is very stricter than absolute liability, but it is wrong. Absolute liability is very stricter. Okay, remember this, and I will also prove this. Absolute liability means that once the prohibited act is proved, the accused is liable and cannot avoid liability by relying on the usual defenses available under strict liability. Okay, by this definition itself, you can easily understand that absolute liability is stricter. Okay, in simple terms, if I need to put this definition, actus reus must be proved for anyways for absolute liability and also strict liability, and mens rea is not required. And also, I said that in strict liability that general defenses are available, but here neither defenses nor nor exceptions are available. Okay, that's why this is most stricter or stringent. So if it is stricter, why did India develop absolute liability? There is a simple reason, because stricter liability was considered inadequate for industries carrying out inherently dangerous activities. So, for example, a chemical factory, is there. It leaks a poisonous gas. Okay, thousands of people are injured. Let us assume if the company could escape liability by saying that we took all the reasonable precautionary measures and reasonable care, many innocent victims may not get any compensation. Therefore, the Supreme Court has evolved the doctrine of absolute liability. And there's a case law, there is a prominent case law related to this as well. I will be discussing in the further slide. Firstly, we need to understand the differences between these two, strict liability and absolute liability. Let us assume that this is strict liability, and let us assume that this is absolute liability. Okay. Now, first, whether mens rea is required or not. Mens rea is not required, and here also it is not required. And in next, whether defenses are available in strict liability or not. Defenses or exceptions are available. Here it is not. Now next, whether this is strict liability is stringent or absolute liability is stringent. Strict liability is less stringent because defenses are available. More stringent. Now next, this applies to many regulatory offenses. Okay, but this mainly applies only in India, that is related with respect to hazardous industries which are inherently dangerous. Mostly this strict liability is concerned with public health or public welfare regulation. Okay, and here it is based on protecting society from the emerging industries which are very harmful, which causes harm to people. Okay, hazardous industries. Now in the next slide, firstly, before I hope have cleared the differences between strict liability and absolute liability. And in a more simple way, if I need to put this, see, firstly, strict liability, no mens rea, no MR, but some defenses there. Okay, and absolute liability, no MR and no defenses. That's it. In the next slide, I will be discussing about the prominent case laws with respect to strict liability and also absolute liability. I hope this is clear. In this slide, we are going to discuss about Rylance versus Fletcher case law, which was held in 1868. This is a landmark case which deals with the strict liability, which was held in House of Lords. So the decision for the English tort law. It was decided on 17th of July of 1868. Okay, this established the modern rule of strict liability for certain dangerous uses of land. Okay, now before discussing the facts of the case, we must understand the historical background of this case. So by the year of 1868, we might come across the Industrial Revolution. So during the Industrial Revolution in 1868, in England, factories required enormous quantities of water. Okay, for running any industries, irrespective of they are dealing with operations of mining or textiles or which are related for any machinery works. Okay, now coming to Ryland also. Ryland is a defendant. Okay, and he is plaintiff. So firstly, what happened is that Ryland owned a textile industry and he wanted a large and continuous water supply. So for running textile mill, he required enormous amount of water. So he constructed a reservoir. He doesn't want to depend upon the rivers passed by. So he constructed a reservoir on his own land. Until here it is clear and it is lawful. But here these are the parties. Parties are Fletcher and Ryland. Thomas Fletcher. The original name of Fletcher is Thomas Fletcher. Okay, John Ryland. Firstly, what about the parties? Fletcher, what he did? He owned a coal mine, and next he operated a mine adjacent to the land of Rylands. Okay. Now coming to Ryland, he owned a mill, textile mill, and he constructed a reservoir. These are the two important facts about the parties. Now, what happened is that unknown to Ryland, unknown to Ryland, old shafts beneath the reservoir. Before constructing the reservoir, we have to look for the any of the old shafts are left, or because under the construction, beside the construction of the mines, there will be old shafts, and old shafts means these are the vertical kind of escalators which are used for mining purposes. So there are leftover shafts under the reservoir. So he was not aware of that. So what he did was, which was connected to the adjacent land with the Fletchers, okay, Fletchers coal mines. So what happened is that after filling the reservoir, water escaped through these shafts and abandoned shafts and flooded to the Fletchers mines. And because of this, Fletcher's mines caused damage. There was huge loss of financial loss. Okay, machinery also got damaged, and because of that, he faced a huge loss. This So he went to the court. He approached the court. Fletcher. What he stated, he argued that Rylands must compensate him. Why should he compensate him? He said that he brought a huge quantity of water onto their land, and that escaped his premises and damaged his property. So he must compensate him. And what did this Ryland argue? He said that he was his intention was not to damage the or incur the financial loss for the Fletcher. So he has no intention and he has no knowledge about the abandoned shafts. So he said that he was not negligent. So here the legal issue arises that can a person be liable for a damage caused by something dangerous escaping from his land even when he was not negligent? See, firstly, the negligent or unknowingly or intention, these three are mens rea. So, firstly, we have to say why was Ryland, firstly, the House of Lords held after clearing this issue, a person who brings onto his land something likely to cause harm, if it escapes, must keep it at his own risk. If it escapes and causes damage, he is liable even without negligence or intention, even without mens rea. Okay. Now, firstly, why did Ryland be held liable? Because there are certain activities that create their own purposes. They must bear the consequences if it escapes. So, the injured person should not have to prove the negligence or intention. This is the uh, lines which are quoted in the House of Lords judgment. So, there are certain exceptions for this strict liability as well. Under this rule, if the defendant could avoid liability in situations such as act of God, which is also known as vis major, okay, it is an event entirely caused by the natural events such as earthquakes or cyclones. Okay, act of stranger, escaped caused by, if at all the escape is caused by the third party, third independent party over whom the defendant has no control. Third party, plaintiff's own fault, plaintiff's own conduct, he only opened the shaft like that. Consent of the plaintiff. See, firstly, this is also known as volenti non fit injuria. It comes under this Latin term. So it means the plaintiff agreed to the presence of the dangerous thing or voluntarily accepted the risk. This is known as volenti non fit injuria. And the fifth exception or defense is statutory authority. That means the activity was authorized by a statute passed by the parliament, and defendant acted in accordance with the statute. So these are the defenses or the exceptions, we can call it. And here in this slide, we learned about strict liability and the case law related to it. This is a landmark case which was held in 17th of July in 1868, which was held in House of Lords. So we discussed about background and the facts of the case, and also the arguments of plaintiff and defendant, and also we discussed about legal issue and why did Ryland held liable, and the House of Lords held this principle, and there are certain traditional exceptions in the strict liability. And in the next slide, we are going to discuss about the essentials of strict liability. Okay, now coming to essential ingredients or elements of strict liability. First thing is dangerous thing. The defendant must bring onto the land something capable of causing harm if it escapes. Example: large reservoirs or gas cylinders. Gas cylinders is a dangerous thing. Also considered as a general thing because all our households have gas cylinder. But here in this case, gas cylinders beyond the prescribed statutory limits. Okay, and also if we take another example such as toxic chemicals and electricity beyond limits, means generators electricity uh, within the prescribed limits, it is applicable, but for considering it as dangerous thing, it must be beyond the statutory limits, so it will be considered as dangerous thing. Okay, coming to the next thing, non natural use of land. But in this case, if we apply dangerous thing in this case, in the Rylands versus Fletcher's case, the dangerous thing is was the large quantity of stored water in the reservoir. Okay, and coming to the non-natural, for all the essential elements, we will be applying to the case of Rylands versus Fletcher. Okay, now coming to non-natural use of land, the use must bring be extraordinary or unusual, not an ordinary domestic use. Same as this. Example: chemical factory or oil refinery, or in this case, example such as large artificial reservoir. Constructing a marine industrial reservoir was treated as non-natural use of land in this case. Okay. Now coming to the third thing, that is escape. The dangerous thing must move from defendant's property to another place, because plaintiff obviously he will be filing the case, and so that we are using here the term defendant. Example: gas leaks into neighbor's house, or if we take another example, chemicals flow into, see, first of all, if there's an industry, from industry there will be effluents flowing. So if at all chemical effluents flows into nearby farmland, the crop will get destroyed. This will be a perfect example for escape. And in this case, if we apply, water escaped from the Rylands land into Fletcher's mine, coal mines, so that machinery caused damage. So Fletcher incurred financial loss. Because of that, he filed a case. And coming to fourth essential ingredient of strict liability or essential element of strict liability, damage. Actual damage must occur. Example: flooding, injury, or if we take another example, property destruction such as machinery in this case. And also in this case, Fletcher's coal mine suffered extensive flooding, and therefore the machinery caused uh, defection and defects, and because of that, he occurred economic loss. And what is the? These are the important essential ingredients or elements of strict liability. But what is the importance of Rylance versus Fletcher's case? See, the importance of this case is the case established three things majorly. Firstly, the doctrine of strict liability doctrine, and the next thing is liability without proof. Proof of what? Proof of fault in certain situations only, not in all. because there are some exceptions. Act of God, in the previous slide I have explained that. And coming to the third thing, a shift from fault based liability to risk based liability to risk based liability. So because of these three things, it remains a foundational case in the tort law, and it has established strict liability doctrine. Now coming to the position in India, what is this case position in India? A person who keeps, means this rule in Rylance versus Fletcher was initially followed by Indian courts, but the rule established is the general rule it establishes the person who keeps dangerous thing on their land. If at all it escapes, then he has to bear on their own risk. This is the rule established in Rylance versus Fletcher. I have explained this rule in the previous slide as well. But here, however, uh, in the initial phase, Indian courts used to apply this. But after MC Mehta versus Union of India, popularly known as Oleum gas leak case. So, after this case, the Supreme Court held that the industries engaged in hazardous activities are subject to absolute liability, not under the strict liability doctrines. Which is this absolute liability is stronger or stricter than English rule or English rule, because English rule has established strict liability rule. So our Indian courts has come up with absolute liability. Now in the next slide I am going to explain the details of MC Mehta versus Union of India. In this slide we are going to discuss about MC Mehta versus Union of India case. This is one of the most important judgments in the Indian legal history because it has evolved the Indian tort law by introducing the doctrine of absolute liability by replacing what? Strict liability, which is from English rule, and the strict liability only for hazardous industries. So this case, MC Mehta versus Union of India, as a law students or as a law learners, you will be coming up with many of the cases in environmental law by the name MC Mehta versus Union of India. So how do we find out? Firstly, we need to check for the citation, and also we need to check for the year and also the other name, that is oleum gas leak case. So it is popularly known as oleum gas leak case. Before understanding this case, we need to understand Bhopal gas tragedy 1984 for because it is important for the context. Next, on the night of 2nd and 3rd December 1984, toxic methyl isocyanate, which is also known as MIC, gas leaked from the Union Carbide India Limited plant. This is a company, subsidiary company. Its parent company is located in USA, in Bhopal. Okay. Firstly, the facts of the case are: Sriram Food and Fertilizers Industries, a unit of Delhi Cloth and General Mills, operated a chemical plant in densely populated area of Delhi. What happened? This factory manufactured oleum, caustic soda, and also sulfuric acid, and also other hazardous chemicals, which was claimed by the environmental advocate or lawyer MC Mehta. He filed public interest litigation bill before the Supreme Court. Until here it is okay. He argued that the factory handled hazardous chemicals such as oleum, caustic soda, and sulfuric acid. Okay. And also it was located in a densely populated area, which was held in the facts. Yes. And he said that plant should be relocated or subjected to stricter environmental regulations, which was reasonable in his claims. And next, firstly, the case was only focused on environmental protection and public safety itself. When the bill was pending, disaster struck. In 1985, oleum gas escaped from one of the units of the factory, and the consequences were very severe. That is, one advocate in Delhi has died after exposure from this gas, because of this gas exposure. And many workers, one advocate died, the consequences, many workers died and also seriously injured. Panic spread throughout the Delhi. Okay. Public concern more about the industrial safety intensified, especially because it was after an year or 1.5 year after the Bhopal gas tragedy. So the case then shifted from a preventive environmental matter to one involving compensation and legal responsibility. Because because of this, the court rejected strict liability from the English rule. That's it. But the legal issues involved pertaining to this case were: firstly, the Supreme Court considered several important questions. Those are: should industries dealing with hazardous substances be held liable even if they were not negligent? Okay. Next, is the English rule of strict liability adequate for India or not? Can hazardous industries rely on the traditional exceptions available under Reliance versus Fletcher? What are the exceptions available? I have discussed in the previous slide. Those are act of God and act of the stranger and plaintiff's conduct. Okay, and what constitutional protections apply when industrial accidents threaten life and health? These are the legal issues. But what are the arguments? Arguments on behalf of the petitioner. Petitioner is MC Mehta. He argued that firstly, hazardous industries create exceptional risk, and victims should not have prove negligence, not prove negligence. In strict liability also they would not prove negligence, and the law should prove stronger protection than English rule, stricter than strict liability. Okay, the right to life under Article 21, that should include right to live in a safe and healthy environment. These are the arguments placed before the court by the MC Mehta, who is a petitioner of this case. And the respondent is factory. The factory argued that it had safety measures and the leak was accidental. So liability should follow the traditional doctrine of strict liability, not the, and also it must be in the ambit and purview of the recognized exceptions which are applicable for this case. It has come up with the exceptions part which are placed in the strict liability. But what is the judgment given by the court? The Supreme Court rejected the reliance on the English doctrine of strict liability. Instead, it created a new doctrine of absolute liability, specifically for enterprises engaged in hazardous or inherently dangerous activities. But why did court reject the strict liability? Because the court held that the older rule, that is strict liability, within its many exceptions, that is, they did not adequately protect the public in modern industrial society. So because of this reason, did not rely, because generally hazardous industries, many big corporate industries, they use the exceptions which are available under the strict liability, and they prevent from paying compensations to the victims themselves. Okay, and what is the doctrine of absolute liability? The doctrine of absolute liability is: an enterprise engaged in hazardous or inherently dangerous activities owes an absolute and non-delegible or non-negotiable duty to ensure that no harm results to anyone. That is, no exceptions are available for doctrine of this. If harm occurs, the enterprise is absolutely liable. If harm occurs, enterprise is liable. Okay. And next, it cannot avoid liability by proving reasonable care and by saying that it is not negligent. So it cannot rely on general exceptions and well as well. General exceptions which are available under strict liability. Those are act of God, act of a stranger, third party, and plaintiff's conduct, and the furthermore which are discussed in the previous slide. Now coming to the characteristics of absolute liability. See, firstly, the characteristics of absolute liability. These are the essential elements. First, there must be a hazardous activity. The enterprise must engage in inherently dangerous activities. Okay, and there must be, firstly, the second characteristic is no need to prove negligence, because negligence is immaterial in this, and as well as for strict liability as well. So this is more stricter than stricter liability. So the plaintiff need not to prove negligence, because the occurrence of harm from the hazardous activity is sufficient enough. And coming to no exceptions. Exceptions, strict liability relies on the exceptions or defenses, but here there are no exceptions, so that's why it is stricter. And coming to the fourth characteristic, it is compensation based on capacity. Firstly, the court observed that compensation should reflect on the magnitude of the enterprise and its financial capacity. The magnitude of the enterprise, if it is larger, means there are big cap industries, corporates, and small cap and mid cap industries, and its financial capacity, its turnover. A large corporation should pay compensation commensurate with its resources. This is the term used by the Supreme Court. Commensurate with its resources means it directly proportional to its resources. So that liability has a meaningful deterrent effect. Okay. And what is the constitutional significance of this case? The judgment strengthened the interpretation of Article 21 of the Constitution. Okay, Article 21, right to life. Okay. And coming to, the court recognized that the right to life is not limited to mere survival, limited to mere survival, and it also includes right to live. Before also I explained right to live in safe and healthy environment. And the industrial development cannot come at the cost of human life and death. Human life and death, industrial development. These are the three things the court has signified. Next, coming to the importance of the case. Firstly, the judgment. It introduced the doctrine of absolute liability by replacing strict liability. It strengthened the environmental jurisprudence, and it expanded the scope of Article 21. This is the importance of the case and the constitutional significance. And I hope you have understood the general principles of criminal liability, mens rea and statutory offences, and strict liability and absolute liability, and the case law pertaining to those strict liability and absolute liability, and how the Indian courts have evolved from the fault-based liability to risk-based liability, and also the essential ingredients or elements of strict liability, and also I have compared the strict liability and absolute liability. I hope you have understood these concepts in a rational way, and by this I think general principles of criminal liability will be ended. And meet you in the next rational concept. Until then, take care. Thank you. Wish you a good success ahead.